Okay, good afternoon, everyone. Welcome to our monthly English estate planning and trust webinar. This is attorney Xiaowei Li, and I'm a partner of ROI Attorneys. Together with me is attorney Michael Li. Michael, can you introduce yourself, please?
Greetings all. It's nice to meet you. I'm Mike Lee, so I'm one of the partners in the office. So, of course, estate planning, business planning attorney. I also have a very heavy tax focus. So it's great to see you all joining our summer webinar. The weather is very nice, but we're inside on the computer. But I think we can provide some good information that could be helpful for doing business in California and throughout the country.
Sounds good. Our webinar is for educational purpose only, and if you have specific questions, please reach out to us either by text message, phone call, or email to schedule a consultation, please. Okay, so today our topic is legal essentials for small business owners. A lot of our estate planning and trust clients are also small business owners. We frequently got questions from our clients on how to deal with some legal and tax issues for their small businesses. So today we would like to share the answers to some of the most popular questions we receive from our clients, and we hope our audience can benefit from today's webinar. So first question, Michael, how should we define small business? Does small business necessarily mean the business income is not high enough or not so many employees? How should we define small business?
Probably helps if I unmute myself. So sorry about that. So essentially, we often use this word small business, in that context, but we almost should use an older term. We sometimes call it like family business, or the more technically legal correct, answer I think is closely held business. And closely held business, it means a business where I have substantial control. For example, if I'm a shareholder in a Fortune 500 company, unless I am massively wealthy, I do not have substantial control over this business. So we're thinking about a business that is closely held, as in maybe it's just me, maybe it's just my spouse and I, maybe it's I and my siblings, maybe it's with other persons, but it's something where it is closely held and I have more direct control or direct involvement in this business.
Yes, I think that some of our clients, their small business actually they are very profitable. Some of them have very high earnings, very good profits. So, I think one thing we really want to tell our clients is, don't think you are not a small business because you don't have enough income or, you have a lot of income. We don't really define small business that way. But as Michael mentioned, it sometimes just means it's a closely held business. It's not a public public corporation. And what forms of legal entities do we usually consider for small business?
So we have a classic spectrum in California of essentially going from very simple but high liability to greater and greater formality and potentially lower liability. And so the situation is like this. So a sole proprietorship, that's just one day I decide I'm going to start doing business. I'm going to start doing my trade. So for example, giving an example of myself, if I'm a lawyer, I pass the bar. I have, obviously, pass the bar, you're a lawyer. I can just put out, we call it hang up my shingle and say, Mike Lee, lawyer, doing business. And I'm just a sole proprietor. And the good thing is it's very simple. I just hang up the sign, I start doing the business. I generally have to get a business license from the city, but I just say Mike Lee, and it's a couple $100 and I have it, every year. And I just report when I receive income. And pay expenses. I report that on my Schedule C, just on my ordinary tax return. Very simple. But the problem is if I get into trouble and I sign a contract, it's just me. I'm liable on that. Or if I commit some malpractice, it's just me. I'm liable on that. Then
Actually, sorry, Michael, just to clarify this, I think some of our clients frequently ask, like, do I have to, since you mentioned, do I have to register my business? Do I have to, like, what do you mean, like a register or registration? Does it mean I have to register with the state, with the local government? What does that mean? And do I have to get a license? If I have to, like, what kind of license you mean?
yes. So generally, what we're talking about is the city business license if you're within the city limits. The San Jose, Mountain View, generally there will be a business license to hold oneself out as a business. And that is fairly simple. This isn't always necessarily needed in some passive businesses, let's say like real estate renting. That one may not necessarily need a business license. It depends on the city. But generally, if I'm doing business, the first stop would be I would need the business license. But that second question, do I need to file something with the Secretary of State? Do I need the LLC? Do I need the corporation? The answer is not necessarily. The question is to really look at your kind of business and to say, what am I doing? What is the risk profile that I'm doing and what is the tax consequences of what I'm doing. And that will guide me. Do I need to do the next step?
hmm Okay, and you mentioned LLC, you mentioned corporation. I think for small business owners, obviously one question we frequently got from our clients is what kind of business should I register? Should I do a LLC or should I do a corporation? So, for example, a lot of our clients they own real estates, and they heard, okay, if I form a business entity and own the real estates via the business entity, that can shield myself from some liabilities. So in that scenario, do you recommend, well, first question first is that true? And then second is, if I want to do that kind of business, should I form an LLC or should I form a corporation?
Yes, so yes and no, and I'll talk a little bit. Real estate businesses are a little bit different. So we'll just mention this with regard to the LLC. That is a passive business where the risk or the activity of the business is from the asset. So the thing to think about if I'm doing real estate renting, typically one would use an LLC, and that would be more commonly done, but it is a spectrum because you have to balance doing the LLC. Yes, that provides a separation from the tenant and the ownership of the the property and me, but it's not appropriate for necessarily every situation. So, for example, if I have, let's say, just a condo inside, let's say, a high-rise building, well, what risk do I have from this? Maybe somebody falls down in the condo, or gets hurt inside the box of air in the sky, but the common areas are under the HOA. There's no land, there's no nothing for this thing. Do I really need the HOA? Do I really need the LLC? And I have to balance this against, well, what does my insurance company say? Do they give me the same premium and the same style policy for the LLC? Or do they make me do a commercial style policy? Because if they make me do the commercial style policy, then maybe it's not worth it. The same way is, do I have a loan on the property? The placing the property into the LLC will generally violate the due on sale clause of the loan, and that can pose a problem. So it's a spectrum for real estate. Is if it's just a single family house, or let's say a condo, probably because of the problems of the lender and the insurance, maybe I don't want to do it, and the risk profile is so small, maybe I want to just stay essentially the sole proprietor, do it directly. Or do I have the asset like this? Is the asset more like this? Is it, and we had a case like this, it was a 5 unit, basically auto repair shop. It was a commercial property. And inside this property, there were the auto lifts that lift up the cars. There was actually the pit bay where you go down these stairs that were very steep and you were underneath the car. Well, that's a commercial property. open to the public. People wander in and out, vendors, solicitors, the public asking about their car. There's, 2-ton cars on lifts above people's heads, super dangerous. And it's already a multi-unit commercial property. That one's high risk. So that one looks more appropriate to go to the LLC than, let's say, a condo in a high rise. And I want to bring it back a little bit because real estate, that's kind of its whole separate thing. Thinking about this, it's the same idea though for an active operating business. So if I'm in a business that is, let's say, relatively low risk, maybe in terms of liability, there isn't necessarily a need to do the business entity, an LLC or corporation. And this is the key thing that I sometimes see misunderstood by clients is I am always liable for my own, the legal word torts. I am always liable for the wrong things that I do, regardless of whether I have a corporation or an LLC. So if I create a professional corporation for a lawyer, or well, we can't practice out of an LLC, but let's say I have one of those entities, and I'm the lawyer, and I commit the malpractice, I commit the injury, the plaintiff will sue me and the business, but they will always sue me, and I will be liable because I am the one who did the work. And so just creating the business entity, the LLC or the corporation doesn't magically insulate one from liability. But let me give you an example of another real case that we had where similar to the real estate with the auto repair shop, where we said you need a business entity immediately. Had a client, tree trimming business, an arborist business, and it was not a small business. Had in addition to the family, there was probably about like 5 people in the family that were sort of the operators, the leaders of the business, and they had probably because total employees was about 50. They had about 45 workers who worked. And what is a tree trimming business? What is the arborist business? This is men and women with chainsaws at other people's houses on ladders, cutting down parts of trees. Crazy, crazy dangerous. People on ladders at other people's houses holding chainsaws, really dangerous. And this is the kind of business where we say, okay, maybe you need a business entity because I, owner of the business, family that owns the business, I'm not the guy on the ladder, with the chainsaw at the other person's house. I'm not going to be the one who's going to cause the injury to the other party. I'm just the owner. And I want to separate this business, the tree trimming business, from my personal assets. Then the LLC, the corporation, is helpful and can be valuable because it creates that separation. And the key thing is I'm not the one doing the service. If I'm the one doing the service, the lawsuit will always flow back to me. But if it's my employee, there'll be a suit against the employee, there will be a suit against the company, but it will end there. The other thing to think about is the taxation. So with generally for LLCs and to a large extent S corporations, the taxes pass through to the owners. So $100 comes into the LLC. If there are 2 members, it goes 50-50, and they each report the $50 on their individual returns. An S corporation is somewhat similar, but be very cautious and star by all the corporations. A corporation always has employees, and the owners, if they are providing service to the corporation, must be an employee, and they must be paid through payroll. The California Employment Development Department is very strict on this. So there's no such thing as like an S corporation that is, let's say, owned by 3 people, and they're the workers for the S corporation, and no one takes W-2 payroll. There must be W-2 payroll. There's a misconception about S corporations, where the rule gets a little bit blurred. That people say, well, I can incorporate my business, and then I can take draws that aren't subject to self-employment or the W-2 taxing system. That is true for some professions, but this operates on the principle that let's say I form a professional corporation, the lawyer, um, that what I do as my labor, I receive a paycheck, a W-2 paycheck for that portion. And the part that my other junior lawyers do, they receive paychecks for their work. But the profit from that profit that didn't have to do with my labor, that comes as a dividend from the company. And that goes without self-employment or FICA taxes onto my return. So that's the key thing to be aware of with corporations, is that you have to have the W-2 system, the employment taxes in play there. So they tend to work well for companies with significant numbers of employees, situations where I want to transfer the stock freely, and that tends to be a better fit. The LLC tends to be more like a partnership plus, where I want to work with um, these particular 2 or 3 people. We're going to have defined roles. I just want to work with these people. I don't want anybody to transfer their interest to somebody else that I don't know. It has to be these 3 people, and we're going to define this, and that's going to be the so total agreement, and that is a good fit for the LLC. So really finding the appropriate um, uh, tool is critical for having an effective and functioning business. Be careful though with the one before LLC, this idea of partnership. Be very, very careful about holding oneself out as partners.
Is it true, Michael, for partnership, you don't even need to register to have a partnership?
No, yes, yes. So you do not need to register. So no, don't need to register. You can accidentally form a de facto partnership. So if I have, let's say, I have, an office, or I have, space, and I meet another lawyer, and we get along, and we begin to practice kind of together, essentially, and we start sharing costs and sharing a profit. We work on cases together, and it appears when you walk in the door that these 2 people are working together. We formed a partnership, even though I said I didn't sign anything. I didn't sign anything with this guy. Why? How are we a partnership? Well, if we start sharing profits and losses and sharing expenses, and it appears to outsiders that we are together, like we hold ourselves out as partners, we are a partnership. I say, well, that's okay. I mean, we wanted to do that. You're right. That's why we started doing all this. Well, what about when that person, gets sued, and then all of a sudden I get served? They're like, wait, Mike Lee, why am I also on this? It's the other lawyer who did this. I shouldn't be sued. You're partners. You're both responsible for each other's basically injuries and wrongs that are done in the course of the business. Even though I say, I wasn't even in the office. I was on vacation. I don't know who this client is. I've never met this person. Why are they suing me? Because you're partners. Partners are all pooled together. So for general partnerships, I strongly recommend avoiding that structure in most situations. Some things classically operate that way. Lawyers and sometimes accountants operate that way, because I can't really avoid the liability of myself. And depending on the structure with the other lawyers, there's no other way. So just be careful with partnership. How do you get around that? You say, well, I want to do that, but I don't want to be responsible for the other person's wrongs. Look at the LLC, or maybe look at the corporation.
Well, Well, let's just continue that this partnership discussion. And you just mentioned we should avoid accidentally falling into this trap of held ourselves as partners. But in reality, I think because different people have different strengths, frequently we need to partner with others to do
Yes.
a business. So, what is the correct way to partner with others? Like how to structure a business when the business has multiple partners.
Yes. So this is really the right way to think about it. So when we start to realize we're going to have to do, I can't do the whole thing myself. That's why I'm looking into this. So how do we design the business? And what we really need to think about, and this guides us, is are we leaning more towards this LLC range, or are we looking more towards like a corporation? Is really the nature of the business. Is the business what we're going to be doing something where we say, well, each person is going to have his or her own defined role. So we're going to have like, we're going to do like a small real estate development thing, and I'm going to be the lawyer, and that person's going to be the contractor, and that person's going to be the architect, and that person, the other person's a accountant or something. That person's the accountant, and we're all going to be kind of contributing our services and doing this together, and we all have our unique roles, and we're going to be doing the roles together. That sounds more like an LLC because we want each person to stay in their role, and the nature of the business is Y, and then we all bring something different to achieving Y, and we have duties and responsibilities that are unique to each of us, and then we share the profits. That looks more like an LLC. If it's something where we say this is fixed and the roles stay the same, and we kind of want the people to stay the same. Contrast this that I see frequently, and it often tends to not work out so well when people have the wrong mindset, is where we use a corporation. A corporation operates, and the rules of a corporation operate like a constitution. It operates like a city council or the government. And what do I mean by this? Is each year there will be a shareholder election, and the shareholders elect the board. They like the city council, they elect the board of directors. And then the directors then appoint the CEO, the CFO, the secretary, and other officers. And these people are interchangeable. And generally, no less than annually, there will be an election, and these things change. So, actually, the large companies, the shareholder, you can see it, if you have a stock account, they have the annual board meeting, and it's a big thing. And they have, the board is large, and they have the stenographer, they write down what everybody says, and it votes just like a city council meeting, just like that. That structure generally has historically been for a larger business, but not always. But it comes with more formalities in the procedure of how business is done. So unlike the LLC, where we say each person's role is somewhat fixed, and John, Susan, Hannah, and Tom, they have each of their roles, and we defined it in the LLC operating agreement, and that's what it's going to be. There isn't really such a thing for a corporation. We shareholders get together, we vote the number of shares that we have, we get seats on the board. The board then nominates and appoints the officers. And this is where, if people are unsatisfied, when the next year comes around to have the shareholder election, we nominate a different board. So that one is much more critical on the formalities of, are you having the shareholder elections? What is the board of directors doing? Are they keeping meeting minutes? Are they doing all of these things? Because that's how that business operates. It doesn't operate based on more of a fixed plan. It operates on like a living constitution as things arise. So that can be a key juncture for the different types of businesses.
Michael, there's a question I frequently got from our clients is how to protect myself if I'm just a passive investor of a business. So I partner with others, but other than the money, other than funds, I do not contribute to anything else, and I do not manage the business. I do not know what the business, up to day. So how to protect myself from the wrongdoing of the business or, the partner?
And this essentially goes like this, is essentially the first step is we would want to define, you know, all the things that we have here. Generally, if I'm going to be a passive investor, I'm generally going to want a business structure like an LLC or a limited partnership because I want the limitation, because I want my risk to end at the amount of my investment. And then I want to define in the LLC operating agreement or the partnership agreement is as the limited member, what are the limits and what are basically the boundaries. So even though I'm a limited partner or a limited member in an LLC, I still want to demand the right to an account. I want to be able to see bank statements, all of these various, different things. So this is something that one has to define in either the LLC or the LP agreement. And this is why I bring up a little bit the limited partnership. The California design of the LLC is a little bit looser than some other states. We're the Revised Uniform Act state. The members in a an LLC, if it's the split LLC where there's a manager and then there are members, the California LLC generally has ability always for the members to kick out the manager. So this is just something to think about if one wants something that's that design, um, because you may want to look more at a limited partnership vehicle. That one really cannot remove the general partner. So you really have to tailor what you're trying to do with the business entities that are available.
Great. Let's move on to the next slide and let's switch gears and we're going to talk about commercial lease. Obviously, a lot of small businesses, the first thing after they set up their business, register their business, they need to rent a space to operate the business. I mean, nowadays, maybe you don't need a physical space, but
Restaurant, barbecue,
yes,
you
still
rent
most of
space.
yes, most of business they need a space. So living in San Francisco Bay Area, I think everyone is familiar with rent control. As we know, residential tenants they are protected by the laws, and the landlord cannot just charge the rent, whatever rent they want, or evict the tenants when the tenants do not pay the rent. So does rent control exist for commercial lease?
Generally, and 9 times out of 10, no, no. I've seen this happen actually in situations where there is the unlawful detainer commercial, and the tenant will cite the rent control, and the court basically just kind of goes like this. They're like, it's a restaurant. You don't live there. The rent control is to prevent homelessness. We don't want people thrown out of their homes. If you're in a commercial endeavor to borrow space, renting space, to earn money in a commercial way, you pay or you get out. So it is not that same situation of like, well, I got sick, well, I'll be homeless or something like that. Is like, if you want to run the thing out of your home, go figure that out. Go do that. But this is a commercial endeavor, so be careful. There's not really the protections if you're the commercial tenant, as there are with um, uh, residential situations. Also, be careful with commercial leasing if you're not familiar with it. Is commercial leasing generally has much longer terms than residential lease. Like residential lease, typically 1 year.
Yeah, I was going to mention that actually. Usually it's about 3 to 5 years, and
Usually 3 to 5.
especially before COVID, we see more frequently it's like 5 years.
And be cautious on this is because one has a lot of exposure for the balance of the lease. And this is something that I encounter with clients all the time is that people will do this, is that they'll have let's say the 5-year lease, and they'll put in about 2.5 years really working the business, and they realize the business doesn't work, and the business is not working. It's not making money. They've personally guaranteed the lease, which is frequently going to happen. They personally guaranteed the lease, and they say, "Well, I'm just going to approach the landlord and just say I'm going to clean everything out, at the end of July, and I'll give you the keys, and we'll call it even, right?" Uh, uh, the landlord will again laugh and laugh and sue your face off for the remaining 2.5 years of the lease. And I've encountered this sometimes with classes who are surprised. I said, "Well, I gave them the keys, I gave them the space. They're still saying I owe 2.5 years." I said, "And attorney's fees and costs that they want." The landlord has a duty to mitigate damages, but they will sue for the whole remaining balance on the lease. So when one takes a term for a commercial lease, they take the whole term, the promise to pay the whole term. And the idea of like, well, I'll just hand the keys back and we'll call it even, that doesn't work. The landlord doesn't want the space back; they want the money. I say, well, yeah, but it's a really onerous and above market lease. It's a really bad lease. I'm like, that's why they want the money, because they got you. So that's the point of it. So in commercial leasing, you do have to be much more sophisticated, much more cautious, sometimes using, of course, attorneys and sometimes also a broker on this on your side, because the negotiation is much more complex and there's much more liability. Naturally, we mentioned a little bit about um, personal guarantees. If you can get a commercial lease with your business entity, the LLC or the corporation, without a personal guarantee, that's great. That's what you want. But very, very few lenders would do that. If I counsel landlords, I say never do that, because they can simply walk away from the company, and all you have recourse to is whatever assets are in the company, which are probably not significant. So in that case, we generally demand personal guarantees, and that makes it risky for the tenant.
So when you sign the lease, you really should keep in mind that it's, for example, if it's a 5-year lease, you need to calculate the total balance of 5 years, not just, a month, a year. You have to execute the full term.
Yes, and you have to really, be aware that we are going to be on the hook for this.
Hmm.
And is that appropriate? Is that appropriate now? Is the business, if this is a new business and we've never tested it and we don't know what's going to happen, and I'm going to go all in on a 5-year lease for an expensive space, you are really going all in. You are pushing all the chips forward and spinning the wheel. It is very risky. And this is also something to drop down, because it is apropos of what we're talking about. CAM expenses. Be very careful of, they call them triple net leases, net leases, because these leases will often say, "Oh, you owe $5,000 a month per month in rent, $5,000 a month for rent." You say, "Okay, $5,000 is okay," but check: do you have triple net? They'll say, "Well, rent's $5,000, but then common area maintenance is 1,000, plus insurance is 1,000, plus property taxes is 3,000. Wait, it's $10,000 a month?" Landlord says, "Yeah, yeah, it is." I say, "I can't pay that, then we'll sue you personally."
That's the
five
key
years.
difference between the residential and the commercial lease we see. Frequently, people don't recognize, other than the rent itself, you are also responsible for the CAM expenses and the
You
property tax sometimes.
and you may. So, like, this is again the key thing of knowing the lease. Some leases are all-inclusive leases,
Hmm.
like for offices, like sometimes like commercial offices are sometimes all-inclusive. That they say, actually, that $5,000 that covers everything. Utilities, taxes, all of that stuff. It's all included. Some say, well, that covers everything except the common area maintenance that can only increase maybe 1% or something, and so it's $5,000 plus a little bit depending on the upkeep of the building. But there are others that are the full triple net, where you may have a situation where the lease payment, the rent payment, is lower than the property taxes, the common area maintenance, all of those other things. So one has to be very, very careful about this to understand, what am I really obligated for? And then ask the right questions to say, well, okay, it looks like I'm on the hook for CAM. Historically, how much has CAM been? How much for this space? You had a tenant before. How much were they paying? What are your expectations for CAM to increase? All of these things. You now have to be very, very careful, because of Prop 19. If you have a lease that passes through property taxes, that maybe you need a clause that the property taxes can only increase 1% per year. Why? Under the new Prop 19, and we've had this happen to clients, the landlord has a triple net lease. Old Mike, I'm the owner of the property. I'm the nice landlord. I have a super low property tax basis because I bought this a long time ago. Everybody's happy. Everybody's happy. I die. My kids inherit the property. They get, again, because this is a rental property, not a primary residence, the county reassesses the property taxes. I bought it for 100 grand. So I'm only charging $1,000 a year in property taxes. It's nothing, but it's now worth $1 million. When I die, the property taxes are reassessed at $1 million. If it's a true triple net lease and there isn't a clause that says you can only increase it, let's say 2% per year, my kids will say, "Oh, good thing we got a triple net lease. Tenant, you owe $9,000 more dollars." The tenant says, "I didn't do anything. It didn't have anything to do with me. It was Mike who died." And the kids say, "Triple net lease. That's why we stuck you with it, because that's your problem. We don't pay the property taxes." If you negotiated the lease out that said it only increases 2% per year, then no, they can increase it 2% per year, just like the county normally does. If there's a sudden reassessment because of change of ownership, because the owner died, then that remaining $9,000, that's the kid's problem. That's not me as the tenant problem. I just pay what I was paying as usual. That is critical nowadays because of Prop 19, because the rental properties will get reassessed. Commercial will always be reassessed now.
Great. Okay, so next, let's talk about the annual reporting requirement for business. I think we already talked about business license quite a bit. So, at the minimum each year for each business, especially the business you register with Secretary of State, you need to do the annual, either annual or biannual statement of information reporting. And also, all the business in California, you're supposed to file for and file and pay for franchise tax, and there's a minimum of $800 of franchise tax. So that's just part of the business costs you need to think about when you register a business. There is another issue I just want to bring up because we talked quite a lot about it at the beginning of last year and even the end of last year. It's about this FinCEN reporting. And we all know now FinCEN has removed the beneficial ownership information. It's also called BOI reporting requirement for U.S. companies and U.S. persons, effective March 2025. For a period of time, it became a big thing because all the U.S. companies and U.S. persons need to file this report, which become a big burden for a lot of small businesses. But now the new rule is you do not need to report that. Only foreign persons and foreign companies need to file the report with FinCEN. Anything else, Michael, you want to add for this part, or we can pass to the next slide?
Just one quick thing. This is just because a question came in, and this is a good place to put it with regard to annual reporting. There was a question came in for partners. How do you report taxes for a partnership? And this is true for a general partnership limited partnership, or often an LLC, generally what you actually do in most situations, if it's not husband and wife, if the two people are not husband and wife, if they're two strangers, generally in most situations, the partnership is required to file the form 1065, 1065, and the California 565. So the partnership or the LLC files a return and says $100 came in, and it says, and we split the partnership, 60-40. So partner A gets 60% and partner B gets 40%. No taxes are paid on the 1065, 565. It's just a reporting return, tell the IRS and the FTB how you're splitting the money. And then that will throw off a K1. And then it is easier for the partner to just enter the K1 onto his or her tax return. So generally the rule is, if the parties are not husband and wife, you file the 1065, 565 combo, and that generally it's a little bit more complicated than this, in that generally it also deducts expenses. So you'd say $150 came in, then we had $50 of all of these expenses, all the expenses went out, we had $100 left, and then it went $60, $40. That's the usual form that one is required to file.
All right. Okay, let's move on to the next issue. We're going to discuss a little bit about contract, business contract, since a lot of business, they need to sign contract with the customers, with the other business, So it's important to understand some basic contract, fundamental information. The first one is the capacity issue. So obviously in estate planning and trust, we constantly deal with the capacity issue. When can we, draft the document for the minor? What if the person lost capacity, has dementia or Alzheimer's? So Michael, in a business scenario, just give an example, like for example, if I own an alarming company and when I visited the house and parents are not in the house and I saw the minor's son is in the house, can I offer this alarming contract, a 1-year alarming contract with the minor's son?
It is an alarming contract because you can't do that. It is an alarming situation. Whenever you contract, you have to deal with someone who has capacity to contract. So if the person is a minor under 18, generally the minor under 18, the contract is voidable at their discretion. So if the minor signs it, the contract, and then I say, oh, well, you didn't pay, or let's say, how about this? The minor signs it, I go out there, I install all of the alarm, and then I send them an invoice, and the parents say, what's this? We didn't sign this. I say, well, you have to pay. I put in all of the alarm equipment. You have to pay. I'm entitled to the quantum meruit, they call it, the promissory estoppel, all these contract things, because I did the work. Law will say no, because there was no agreement, because the minor doesn't have capacity, and it's voidable at his or her choice. Even though you say, well, I expended all of this money, I did all this work, they say no, because it is voidable in their favor. You went with somebody who didn't have capacity. Similarly, the same way, if someone is elderly with dementia, you have to be careful about this. So capacity is critical for the old and the young. It's also critical if you deal with other businesses. So tip, if you are contracting with a business and you want to bind the business, if they're a California business, what should you do? Go to the California Secretary of State website and do business search, and find the statement of information and figure out who's listed as the CEO, CFO, secretary. And generally for a business contract, generally the business contract to be be enforceable against the business should be signed by two officers, the CEO and the secretary, or the CEO and the CFO. Or if it's just one person, I'm all of those, there should be two signature lines. Michael Lee, CEO, Michael Lee, secretary, I sign it twice. And this is the key thing. Make sure the person signing the contract is the person on the statement of information. Because if all of a sudden it says Joe Smith, CEO, and then I say, company, why didn't you deliver the thing on time? You didn't deliver it. There's a big problem. I want damages, or I don't want to pay, or whatever the situation is. And they say, why did you sign with that guy? He doesn't have anything to do with the company. He's just a salesman. He can't find the company. He doesn't have authority to do this. It's good to check, because I've encountered that, of where it was basically kind of a rogue, like, salesman for the company, who was trying to make commissions, not necessarily in bad faith, but was sort of entering into deals with people that he didn't have authority to do. And then the customers got mad. They got mad at the company. So that's something to take a look at with with companies. There's a rule for how they have capacity on the statement of information. Minors, older persons, like that.
For estate planning, we frequently drafted power attorney for our clients. So can power attorney, for example, if I'm the CEO of the company and I sign a power attorney to an agent, and can I authorize the agent to sign the business contract on behalf of me with other business or other individuals?
There are commercial powers of attorney, but if that's happening, be very cautious, because the rules are complicated, and these things are strictly construed. So if one's using like an estate planning power of attorney, we really got to look at that, because that's generally not the right power of attorney. There
Mhm.
are commercial powers of attorney, and in fact, power of attorney came from the commercial context, actually. So there is a long history of these, but they look very different than the ones that actually most people see. So they're very prescribed in the kinds of powers that the agent would have.
Okay. And another, I just want to, bring up, because I say that all the time, because, we have a lot of Mandarin speaking clients, and a issue frequently came up is, when somebody try to defend about the contract, and one defense they use is, I do not understand English. I do not understand the English language. I only speak Mandarin Chinese or Cantonese. I don't understand the contract. Can that be a successful defense in a litigation case?
In and of itself, it is not going to be an easy defense, because one signed it. But then the question always comes about is what was the agreement? So basically, what will always come out is, well, I didn't agree. I didn't review this and sign it. Well, that in and of itself is not going to be enough. What you'd have to argue is, say, well, they told me in my native language that it was this way, and so we have to interpret the contract with these oral other provisions. So I don't think that this is a way out. Basically, what it's going to cause is a mess. And so be cautious with signing contracts, obviously, because it can be messy. There isn't necessarily a simple way to exit the contract. Just saying, I don't speak English.
I don't understand.
Yeah, I don't understand. English is not going to work, because I'd say, if I say, oh, I don't understand the contract, well, I mean, nobody would pay a mortgage ever, because they'd say, look, it's 47 pages long. It's in, size 6 print. I don't know what any of that means. I didn't know what it was signing. That's not going to work. Because they say, did you get the basic understanding that when you were signing this thing, you were obligating yourself to a lot of terms? I said, well, yeah, I mean, I knew that. I didn't know all of the terms. Said, but you knew whatever was on that paper, you were going to obligate yourself to, right? It's like, because that's how signatures work. Is it what? Yeah. Is it, well, then what's on the paper is what you're stuck with. We don't require you to, we don't make everybody who signs a document go to law school to understand what's on the document. If you know it's an important document, what you should do is go get a lawyer to tell you what it means. Once you affix the signature, they say, well, then you either knew what it was or you waived it. Is essentially you said you agreed to whatever was written in there. So that's not an easy out. So that would exercise some caution there.
Well, last but not least, I just want to mention, a little bit about this consideration issue. So, what does consideration mean? So, for example, if you sign a contract to buy a product for $50,000, and later on you found the same product on Amazon, for example, it can be purchased for $10,000. Now, can you back out from this $50,000 contract? Well, the answer is you can't because you negotiate the deal. You sign the contract, even though it may be a bad deal. You have to live with the bad deal you negotiated and you signed. So, consideration can be $1, can be, $1,000. But once you sign a contract, that's, there's no this so-called like equal or, a good deal. You sign a contract and that's the deal. That's what it means.
Yes, that is another thing too. We every once in a while we do encounter this where people think that a court will reform a contract for fairness. There is not a concept of there actually, it's interesting, there in the German legal system there is this concept, is the contract true and glauben, and it's like true and right, and there is some idea of like fairness in the contract. The English common law, which we use, does not worry about fairness. They basically say, did you understand this was an important thing? Did you agree that you were entering into the important thing? And you are stuck with the important thing. We don't second guess the business decisions of it.
Mhm. Okay, let's move on. We have about 6 more minutes. So obviously not every business work out. Some business, we see that a lot in the past few years, during COVID. I mean, some business make a lot of profits, but others, they are in deep financial crisis. Actually, Michael just mentioned a lot of them because of the commercial lease. So I think when business they're struggling, they have some crisis. One easy solution. A lot of our clients would like ask is, can I file bankruptcy? I think nobody is more suitable than Michael to answer this question as a bankruptcy specialist. Is bankruptcy filing that easy? Like if you owe somebody money, if you sign a bad contract, if you can't pay the lease, can I just petition for bankruptcy?
Well, I would say bankruptcy is there and is a unique thing in American law that it can provide relief, but the relief requires honesty and good faith and some work. So for a business, I would say what is one of the biggest issues that I have with businesses for either wind up and dissolution, this is basically closing the business under state law procedures, or filing the company into bankruptcy, is this problem, is that there are personal guarantees. I can wind up the business and close the business for you, or I could file it into bankruptcy and basically be the end of it. But if you personally guaranteed the debt, you're still liable on it. And so this is the thing, like with the personal guarantees, that is the loose thread, which is critical, is that if I wind up the business, it doesn't really do anything if there's a personal guarantee. But on the converse, there are situations, so we do fair number of commercial bankruptcy cases to wind up businesses. Is what about this? A real case that we had. There was a business that was essentially in the process of winding up. Things weren't doing so well. It was a mirror business, and it was mirror and like glassware for houses and things like that. So basically, a lot of glass stuff. And a friend of theirs had a big warehouse, and they said, "Well, you could just put all the glass stuff into the corner of our warehouse, into the racks and everything, and we'll save it for you until you figure out what to do." Well, the business essentially realized that there was going to be no ongoing business. They couldn't make it profitable, but their inventory, those mirrors and everything, was very, very valuable. But at the same time, dealing with those mirrors, getting, hiring people and getting forklifts to go through it and everything, was very expensive and dangerous. It's a whole bunch of glass stuff. And so it was really a perfect bankruptcy case, is that the owners of the business said, I don't know how to operate the forklift. I don't want to do anything like with this. All I want to do, can we just like appoint somebody to go in there, hire an auctioneer, sell all of that, get that out of there, and then any of that money that's left over pays the creditors, and then we're just done? Yeah, we can do that. That's bankruptcy. I had the same thing happen. There was a very large, actually, dental manufacturer in Los Angeles, and it was the same thing. They say, we have, we placed most of the orders, but we have a lot of equipment on hand. We have a lot of materials. We have a lot of inventory. We have all of this stuff. And this was a whole warehouse. We have these commercial leases that we owe a lot of money on, and they know that we have valuable stuff because, I mean, they see what we have in the building, but it's not personally guaranteed. And we want a transparent, lawful way to just say, a neutral person came in, they sold all the stuff, they paid out as much of, all of the assets as they could, and now it's over. So bankruptcy works well for that. Why would you do this? Be very careful about this, of accidentally putting yourself on the hook. Beware that in business situations, in commercial situations, if I have a business and I'm starting to get, let's say, a lot of debt, and it's not personally guaranteed by me, I don't have any personal guarantee on the debt. So if I owe, $100,000, and I sell off all of the inventory, and there's $50,000. If I take that $50,000 out of the business, just sort of, yoink, and it's not for payment, it's not for salary, it's not for anything, I just take it and then close the business or just ignore the business, I have now placed myself at risk of suit for that $50,000 because I essentially stole it out of the business. It was supposed to go to creditors, and it was supposed to pay them, and it should have paid them 50%, and then I would have gotten nothing. So be careful, because in some businesses, creditors will be aware of this. For example, like the IRS, if you take the money out and then file a tax return and there's a balance that's not paid, they're going to ask where that money went. Be careful, because you made kind of a bad situation worse, in that if you just paid the money over and walked away, you would not have any liability. The business entity, limited liability, and you didn't personally guarantee anything, no liability. But when I took something out, I then created liability by wrongfully taking it.
Okay, it's 1 p.m. and I think well, we have one more topic, but I just want to summarize, because sometime this year we'll have another webinar to discuss about this. It's business succession. So if you have your own business, sometimes you may wish to keep the business within your family if you pass away, or you may want to sell it after you pass away. But in any case, you need to do some planning to ensure that the business can stay up and running, and especially to avoid probate fees and avoid any tax liabilities. So we are running out of time, but I promise sometime later this year in the fall, we'll have a separate webinar to discuss about this topic. And thank you so much for joining us, and thanks, Michael, for joining me today. And we'll see you next month. Have a good afternoon.
Yes, and enjoy the good weather. Take care.